Hey, I'm Bo. I'm an attorney. I've been practicing in personal injury for the last 10 years, both on the plaintiff side and the defense side. What I'm hoping to do is provide a unique perspective to personal injury law and provide some education materials both to consumers and potential clients so that they can make better decisions. All right, we're back for the second time on this podcast, and I got a lot of feedback both at the house and from friends. So initially what I want to do is go back and clean up just a few quick things. My wife told me that, per usual, I don't do a good job of selling myself. I didn't do a good job bragging on myself. When I talked about the kind of my academic career and path to where I'm at now, I gave you all the bad things. And those are the things that stick out in my mind. I really don't talk about the good things. Maybe that's a personal flaw that I have. But in any event, I've been told to make sure that I touch upon those things. So real quick rehash, real rocky start, high school, college didn't start off great, and we kind of went from there. My last 2 years in college, I had a 4.0, did really well. Scored in like the 87th percentile, I think, on the LSATs, which that's really good. Considering the bell curve part of it. When I finally got to law school after the military, I was on the dean's list every single quarter, ended up getting a merit scholarship on top of the scholarship I had prior to that. I scored, I don't remember what the scale on the MBE was, the multi-state bar exam, the multiple choice part was, but I do know that I scored well enough on just the multiple choice part that I could really just write my name on the essays. There was a guy I was working with at the time. He was real impressed by it, and he would tell you the score. He probably remembers. I don't. Flashing forward, we went out on my own pretty much a year after I got sworn into the bar, and we've been doing well ever since. I cannot complain at all. The colleagues in the bar have really welcomed us and embraced me. Some older lawyers have taken me under their wing and helped me out as far as just pointing me the right direction on things. And, I was really proud that, in your 5th year as an attorney, you become eligible to be rated by Martindale-Hubbell. This is something that attorneys work their entire career for, to have an AV rating. There are 20, 30-year lawyers that don't have that. I was able to get that in my 5th year, which was a big thing for me. And then we were rated by super lawyers every year since then. I have a great client base. I can't complain at all. I'm entirely blessed with where we're at. But I just want to get that out there because last time I made it sound like, hey, we got here by the skin of our teeth. That's not necessarily the case. I was just giving you some flavor for what my background is. So enough of talking good about ourselves. Let's talk about the actual topic at hand. So what I want to talk about today, last time we talked about, the overarching theme was how to go about selecting a lawyer. And I want to move past that today to talk more about how a case should progress in the early stages and things that you should look out for. So one big topic right now is medical liens. So what is a medical lien? Well, if someone's involved in an accident or a shooting or however they may get hurt, clearly they have to go get medical treatment. Well, their access to medical treatment may be hindered by lack of health insurance. So really what I want you to think of is 2 separate paths. There's the path where you have health insurance and the path that you do not have health insurance. Those 2 paths should never cross, because if they cross, you've got a real problem, and we'll talk about that. So I'm going to leave the health insurance alone. You go see the doctors that accept your health insurance, you treat, and hopefully you get better. You get back to where you were. But what do you do if you don't have access to doctors? How do you do this? So there are medical providers out there that will treat you on what's called a lien. So you go see Dr. Joe, chiropractor Joe, physical therapist Joe, whoever it may be, and you sign a document that basically says this: in exchange for the care received, you will pay back Dr. Joe out of anything that you recover in your case. But in the event that you don't recover anything in your case, you still owe Dr. Joe that money personally. That's one thing that's often left out. People are sent to doctors, chiropractors, and whatnot by their attorneys, and all they're told is, hey, we'll pay for this out of the case. We'll pay for this out of the case. I've never seen a lien that says if you don't recover in your case, you don't owe the money to the doctor. They can't say that, because if it did, then Dr. Joe's credibility is just completely out the window. You have to be personally liable for it in the event that you don't recover. So that's one thing people need to know about. You can be personally liable for these liens in the event that you don't recover. Second thing is you need to be aware of the billing rate. So say you go to a doctor and you have health insurance. Well, your health insurer has a contract with that doctor that sets out a fee schedule. So a Band-Aid costs this, all these different things they can do for you. There's codes for them, and they cost a certain thing. And those prices are negotiated in mass by your health insurance company. But when you go treat on a lien, you don't have that mass negotiation power. You don't have a national health insurance company negotiating on your behalf. It's just you and Dr. Joe. Dr. Joe may have a separate fee schedule for people like you, people who do not have health insurance and people who are treating on a lien. More often than not, that fee schedule is artificially inflated. There are doctors that are charging 500% and 800% of what they would charge other people for the exact same procedure. I've seen surgeries cost $200,000 when they should cost about $42,000. I've seen injections that should cost $100 costing thousands of dollars. So you need to be real careful about those fee schedules. You need to understand that the person or business that is responsible for injuring you, whether it be a car wreck or a slip fall or negligent security, however you got hurt, you need to understand that the person that hurt you is only going to be liable for the reasonable cost of necessary medical treatment. Reasonable and necessary. Well, if you get sent to one of these doctors or chiropractors that are charging these absurd rates, it's really hard for you to say that paying $500 or $100 for a Band-Aid is reasonable. The other side is going to pick up on that, and they're going to use that to defend the case. I have seen cases where the defense settles for much less than what the medical bills are, which is ridiculous. But they're able to do that because these medical costs are so high. And at the end of the day, the person left holding the proverbial bag, if you will, is the client, because the lawyer's got their third, their 40%. The doctor's going to get paid because you're contractually obligated to pay the doctor. Who gets pinched in the middle? The client. So be very wary about treating on liens. That's not to say that they're bad. Liens have their place, and they can be very beneficial to both a person being able to receive care and for the case itself. But they have to be used appropriately. If they get out of control, they can absolutely kill a case, and they can leave a person in a position where they're so financially compromised that they cannot get the care they need without going into even more debt. It's really a debt trap, so beware of that. Another topic that you need to be cognizant of is if you miss work, if you miss employment, or if you miss out on money you would have otherwise made because of your injury, you need to be sure that that is documented properly. What does that mean? Well, if you get injured and you just don't go to work for 3 or 4 days after the injury, or months, and you don't have a doctor actually write you out to say, hey, this person cannot work right now, you are running a risk of not being able to recover for those lost wages. If I see a person who has just not gone to work for a week, a month, a year, whatever it may be, and they sit down and they testify, hey, I just couldn't do it. There's no way I could do it. I was physically incapable of doing it. But all the while they're going to see a doctor and they're not asking the doctor to write them out of work, and the doctor's not putting them on any sort of restrictions for work, then that lends itself to suggest this person could work, they just didn't want to. All that person would have had to done, all the attorney had to do was make sure that their client knows they have to ask Dr. Joe, hey, can I go to work based on your examination of me? And if Dr. Joe says no, then, hey, Dr. Joe, please put that in my records or give me a work excuse. Those work excuses make all this back and forth about whether you could or whether you couldn't work go away. So make sure that you get a work excuse. The next thing with lost wages is make sure that the money you missed out on is properly documented. For an hourly employee, that's pretty easy. Miss Smith works 40 hours a week. She gets paid X number of dollars. So that math is pretty easy. But what if you have someone who's more of an independent contractor that doesn't have they don't know exactly what they're going to make? For example, a waiter or a waitress, presumably they have a base amount that they're paid, but then a lot of their money comes through tips. Tips can go up and down. You can't just rely on their hourly wage at that point. What you'll have to do is go back and get their records from their employer showing what wages they reported, what the actual paper trail says. You never want to get in a position where you say, hey, I make X number of dollars a week, a month, whatever it may be, but that's not what the paper says. The paper says Y. Surely no one watching this would do something like that. But you're going to have to go with what the paper says. And you're going to have to actually get that paper trail to show what you missed out on. It gets even more complicated with a person who's self-employed. It's dependent upon the amount of work they have available, things like that. There's all kinds of factors that go into how much a person who's self-employed actually makes. For that, we start off with the tax returns most likely, or a profit and loss statement, and work from there, and possibly get some sort of expert involved if it's a substantial lost wages claim. I have seen a lot of cases flounder on lost wages because the attorney simply says, hey, my client was out of work for 3 weeks, they're owed this much money, but they put nothing else on the table to actually prove that up. Last time we said insurance companies are businesses. They're in the business of settling claims. They're in the business of resolving claims. But what they're not in the business of doing is just handing out money. If they just hand out money, then they're going to be out of business. So the plaintiff's attorney has to take it upon themselves to put together the documentation necessary to show the insurance company, hey, this was a real loss and this is how much it was. If you do that, more often than not, insurance companies are happy to pay claims because that means they don't have as many of them hanging around. So it's all about putting together the proper information. Next thing I want to talk about is another reason that so many cases go into lawsuits. Just a clarification of a point that came up from last time. Last time we did a little video that said 99.9% of the time cases don't go to trial unless there's a free swing. Okay. First of all, that 99.9% may have been a bit of an exaggeration. It's more like 95%, just to characterize. But you get it. The vast majority of cases are not going to trial. That being said, a ton of cases go into litigation. So what's the difference? So from the time of the incident until a lawsuit is filed is considered pre-suit, like before a lawsuit's filed. That's what it's classified as. Once a lawsuit's filed, it's in litigation. It may be in litigation for years. And then at the end of the litigation, it culminates in a trial. Okay, so the trial is pretty much the last stop on this train you're on. But a ton of cases go into litigation as opposed to settling without litigation. So why is that? First of all, you got to look at the fee contracts. I think this drives a lot of people. When you sign up with an attorney or when you engage an attorney in a personal injury case, fees vary. The industry standard is that if a case gets settled pre-suit, like before a lawsuit's filed, it costs a third. And then if you have to actually file a lawsuit, it goes to 40%. That's roughly a 7% increase. That's one financial motivation. Let's just be honest. We're all human here. There are times I see cases and I scratch in my head like, why on earth would this person file this lawsuit? Why would they do it? And the only thing that I can come up with at that point in time is, somebody's getting that extra 7%. I hate to say it like that, but those things happen. We're human. We all have our motivations. But cases, more often than not, don't need to go into litigation. There are cases that need litigation and cases that don't, that have nothing to do with the value of those cases. If you put together a properly supported demand and send it to the insurance company, and a key word there, the key phrase is properly supported, that's realistic, more often than not, you're going to settle the case. It's better for everybody. Sometimes, not always, but it's better for everybody because the client doesn't have to wait years to get the money they need, to get the medical care they need. The insurance company doesn't have to hold the case on its books for years. It's better for everybody to resolve things quickly, if possible, if it's appropriate. And sometimes it's not appropriate. But you want to make sure that you send a supported demand. So what is a supported demand? At its very basic, what you're going to see is a copy of some sort of incident report. It could be a police report saying that this crime happened here and this person was hurt. It could be a traffic crash report. The police give you, says, hey, there's a motor vehicle accident. This is what it was. It could be a report written by a business where something happened, where they document, hey, these are the events that unfolded. But there needs to be some sort of report. There also needs to be photographs and videos, if at all possible. These are things that need to be documented from the get-go. So why not have them early on and include them in a demand? Photographs of the scene where the crime happened, photographs of the vehicles involved, photographs of the injuries. If appropriate, maybe a video showing the limitations that a person has. Things to document this stuff and make it actually tangible. The next thing a supported demand will need to have, of course, are your medical bills and records to date. Those are pretty standard. In our demands, we often take it a step further. What we'll do is we'll go talk to the doctors and say, hey, doc, Miss Smith over here, we represent her. These are the records that you've produced. This is the treatment that you've given her. Would you mind giving us a medical narrative? Medical narrative is simply a tool by which we can get that doctor's testimony into evidence cheaply. Doctors, they're businessmen. They're not going to take 2 or 3 hours out of their day and come sit down with me in my office and let me videotape them for free. Doctors are going to charge thousands of dollars to come do that. But with a medical narrative, we can write it, give it to the doctor, give the doctor an opportunity to make any changes the doctor wants to make, have them sign it, and there we go. We've got, a page, 2-3 pages worth of their testimony that's admissible that would be admissible in court and evidence because of some evidentiary rules. But we're not waiting until the day of trial or 6 months before trial to do that. We're doing it up front to show the insurance company that we are actually prepared to go that route if necessary. So we'll put together medical narratives. If a case warrants it, we might have an accident reconstructionist go out or some other sort of expert to do an analysis of how this all happened. It's funny, I tell people all the time, like you've got what you remember, and everybody's kind of, to varying degrees, they can recollect what happened a week ago, but you pull them back 2 years after the fact, their recollection is not going to be that good. They're going to remember what they want to, what was important to them, but the details they're going to lose. When we send these experts out, they'll take into consideration the testimony. I mean, they have to consider everything, but they're really basing their analysis on measurements and time. And it's science, people. It's, there's science behind it that you just can't deny. In addition to that, if the person needs follow-on medical care, if, Miss Smith has a condition that's going to require treatment, surgery, whatever it may be in the future, we'll go ahead and get an estimate done. We'll go engage the services of a hospitalist to say, hey, this is the treatment that Miss Smith is going to need over the next 20, 30 years, whatever it may be. This is what we project the cost to be. We'll include those things in our demand. Sending a well-supported demand that you've got everything done that you could possibly do at that point in time tells the insurance company that this is being taken seriously. We take it seriously. And it gives them a basis to decide what their value is. You've got to give them information in order to get a number back. You can't just call or just send a letter and say, hey, Miss Smith was in an accident yesterday. She went to the emergency room. Your policy limits are $100,000. We want them by tomorrow. The insurance company can't do anything with that. You have to give them information to allow them to make a reasoned decision. Again, insurance companies are not. I mean, I'm not going to get down on them that much because they're in the business of settling claims, but they're in the business of paying reasonable amounts for claims. If you give them the information they need to make a decision, they'll do it. Just make sure that your attorney is sending a supported demand. Next topic, unrealistic. Well, we could just do one on unrealistic and put all kinds of things at the end of that. Unrealistic expectations, unrealistic timeframes. Those are two things ripe for discussion, so let's talk about those. Unrealistic timeframes. If I handed you 3,000 pages of medical records and documents and photographs and so on and so forth, and I said, I want you to make a couple $100,000 decision about this by tomorrow, you'd look at me like I was crazy. You can't process 3,000 plus pages in that time frame. You can't do it. The law, typically, in the context of motor vehicle accidents at least, prior to a suit being filed, gives an insurance company at least 30 days to respond to a demand. I'm of the opinion that if you send a voluminous demand with thousands of pages and an insurance company asks you for additional time, you should give it to them. When an opposing party or an insurer asks you for additional time, what they're telling you is, hey, we're actually looking at this stuff. Give us time to actually look through it. So many people just bang their hand on the table and say, hey, 30 days is 30 days. That's all you're going to get is your 30 days. Well, you're tying their hands at that point. What if they simply cannot get through the information in 30 days? At that point, they have no alternative but to reject your demand. You know, be reasonable with your time frames. If you send 100 pages, then 30 days should suffice. But when you're talking thousands of pages, give them additional time. Unrealistic expectations. I think this is a pet peeve of mine, and I don't want to rehash everything we talked about last time, but I'm of the opinion that people's expectations are driven by what they see and what they hear about other cases. Well, you've got these, I'm going to call them big TV firms, is what I'm going to call them. The ones, the biggest firms on the earth, or the biggest firms in Atlanta, so on and so forth. They're putting out advertisements to say, hey, we got Miss Smith $1 million. We got Miss Smith $500,000. We got Miss Smith $100 million, whatever it may be. But at the end of those, they tell you, well, every case is different and we can't guarantee you $1 million. Well, if that's the case, why are you telling me about it? If every case is different, what benefit is it to you to tell me that you've got this $100 million or $1 million settlement if you're just going to in the same breath tell me, well, I can't do this for you necessarily? We all know what the reason is. It's to set that expectation. It's to set the expectation that, hey, this is what I can get. But what they don't tell you is these large firms are processing thousands and thousands of cases. I cannot emphasize that enough. Thousands and thousands of cases. And they are picking out one, maybe two a year that they're going to actually tell you about. They're not going to tell you about the other 9,999 cases that were just ordinary or mediocre. They're going to tell you about the one. I'll be straight honest with you. You give me the right set of facts, I'll let my 14-year-old son settle that case. He's got no law degree, no experience. He'll get him $1 million too with the right set of facts. It doesn't impress me. Realistic expectations, what does that mean? Well, it gets to valuing your case based upon the merits of your actual case. And that takes somebody to sit down with you and explain to you how these cases are evaluated. So I'm going to give you just a quick rundown of how to evaluate a case. Now, this is just how I do it. There's no way to say a case is worth X number of dollars with 100% certainty. Nobody can do that. Insurance companies and attorneys, they have, computers with artificial intelligence that try to do that, but they can't do it. And there's a number of reasons they can't do it. But what are we looking for? You'd start off with the medical bills, because those are tangible. We can say, hey, Miss Smith has X number of dollars worth of medical bills. This is what she has. Assuming those are reasonable bills and reliable, we can use those bills as a starting point. The next thing we're going to look at is the length of time that Miss Smith treated. Miss Smith entered treatment on January 1st, and she treated until Christmas. The next year, she treated approximately 12 months. That's something that we can say for certain, the time frame. Then we're going to look at the injury. Was this an injury that was debilitating, or was it an injury that just was aggravating? What I mean by that is Miss Smith able to go about her day, but she just has neck or back pain, or does her leg hurt? Or is this a situation where Miss Smith just couldn't do anything for an extended period of time? We take that and we assign that a value. And the value we assign it is dependent upon a lot of factors that I'll talk about. But anyways, we assign that value, and you can multiply it out over that course of time to get an understanding of what her pain and suffering might be worth. And these are going to be ranges, high, low, and mid-range. We'll multiply it out. And then you ask, okay, when she stopped treating, is she still going to have issues? Does she need further treatment? And if she's still going to have issues, we use that same multiplier out into the future. If she's still going to have medical expenses, we determine what those are going to be and add those in. If she has lost wages, we add those in as well. What the multiplier is is really dependent upon a number of things. And we could come up with new things all day long, but I'm going to give you just the basic ones. The biggest one is the venue. Every county is not the same. That's how Georgia sets it up. You have to sue in the county of the defendant's residence. So, like for me, I work in Sumter and Dougherty County, but I live in Crisp County. So if someone wants to sue me personally, they have to do it in Crisp County, assuming they stay in state court. If I get in an accident in Atlanta and hurt somebody, they've still got to come to Crisp County to sue me. So what county the defendant resides in is of critical importance, because counties are made up differently. The people in those counties, painting with a very broad brush here because I understand everybody's not the same, but we classify these counties as conservative, liberal, moderate, and that's real quick rundown of it. In a conservative venue, your multiplier is going to be less because the idea is the people there have more conservative views when it comes to money. Therefore, they won't award as much. Moderate, you get what that is, and in a liberal county, the school of thought is they have a more liberal view of money. Therefore, they're going to award more. So that's how venue can play into it. And then the multiplier, of course, you got to talk about the actual injury itself. If it's if it's debilitating or just aggravating, those are two quick breakdowns of it. If it's just aggravating, it's going to be less than if it's debilitating. But you have to go through this process and look at all these things to get a realistic idea of what a case is worth. Now, equally important to determining what a case is worth is determining what recoverable money is there out there. So if the person who injured you is indigent, meaning that they could not pay a judgment if you were awarded a judgment, then you're going to be stuck with whatever insurance money there is. And there are tools to help us find what insurance money is out there. First, the person who injured you, their insurance, and then your own insurance. But there are multiple layers. I see very often that attorneys skip over additional layers of insurance that could have been beneficial to their client. In an ideal situation, what happens is the reasonable value of the case matches up perfectly with the amount of insurance that's available. That's a perfect world, which means it rarely happens. More often than not, you're stuck in one of two scenarios. Either you have a catastrophic case where somebody died, but there's only minimal coverage that'll never even come, not that money could compensate for it, but they'll never come close to compensating for it. Or you'll have an injury with a lesser value with an exceeding amount of coverage. Let's kind of talk about those scenarios real quick. So in the scenario where you have a catastrophic loss and minimal coverage, this is where I talk about people putting their hands in folks' pockets. If you come to me with a wrongful death case, let's do something classic here. It's a pedestrian strike, okay? James Smith was walking down the road and Jill Jones hit him, plowed him, killed him, and Jill Jones is at fault. Well, Jill Jones has got $25,000 worth of liability coverage. That's it. Well, the person who's hit, their family goes to an attorney and says, "Attorney, what should we do?" Attorney says, "Well, sign this piece of paper." Attorney gets the case. He gets a death certificate and an accident report. That's all that person has to get. Sends a letter to the insurance company. The insurance company sends back a check for $25,000. So fast fireballs are coming off the sides of it. The lawyer did nothing in that scenario, nothing to earn their fee whatsoever. If that lawyer was truly helping their client, he would have told the family, "Hey, all you've got to do is get a death certificate and call this person and tell them you want your money." That's all he had to do was tell that person that. Is it ethical to take a third for doing what that attorney did? That's really not up to me. That's up to the bar. I just know that if I were that family after the fact, I would be upset about it. So beware of that. On the flip side, you have too much coverage for the injury. In that scenario, the defense has all the leverage because they know on their worst day you're not going to eclipse their coverage. So how do you get around that? How do you do things to prompt a settlement at that point? Well, it really goes back to what we talked about earlier. You make sure you send a well-supported, thoughtful, and properly evaluated demand. You say you have to. You can't just say I want all of it, because if you say you want all of it, you're going to be fighting forever because you're not entitled to all of it, more than likely. You have to have a really well thought out demand that says, hey, we will accept this, and leave the rest of that coverage on the table, because you're going to end up fighting for years over that, and you're probably not going to get it. So a well thought out demand. I want to make one thing real clear. We are always willing to go to trial. If the client wants to go to trial, we're willing to go to trial, and we're going to do everything we can in our power to make sure that trial works out in the client's favor. So don't take all this as meaning, hey, they don't go to trial, they're not going to fight for me. That's not the case. But what I don't want to see a client do is spend $1 chasing a dime. I don't want to see them do that. I want to be able to tell them, hey, reading the tea leaves, looking down the road, this is where you're headed. I want them to have good information so that they can make the best decision for themselves. I don't want to just put blinders on them and say, hey, we're going to trial no matter what. I want them to have every opportunity to resolve their case under terms they're happy with. I have a lady right now, super sweet lady. I don't know if anybody is from Plains, but I've not met one mean person from Plains yet. Someone may prove me wrong, but this is the sweetest lady I think I've ever met or had the pleasure of representing. She does not care. If I told her she was going to get $1,000 back, she would be just as happy as if I told her she was going to get a couple $100,000 back. She does not care. I am having to hold her kind of at a stiff arm in a polite way, letting her know, hey, you should not accept that. You should not accept that. We know what your case is worth. We're going to get there. And she said, I'm happy with whatever. I don't want clients just to be happy with whatever. I want clients to be happy with what they actually get. In an event a client tells me, hey, I'm not happy with this, well, then we're going to go back to work and we're going to figure out a way to get them more. This is all just information. This is information about things we can do short of a trial. This is information about things that people need to consider when they are potentially facing a trial a year or two later. But under no circumstances should this be a suggestion that we're going to shy away from trial at any point in time, because that's certainly not the case. All right, guys, hope you got some value out of that. If you're listening on a podcast, we'd really appreciate it if you leave us a review. If you're listening on a video platform, if you could like and share, we'd really appreciate it. Maybe share it with a friend that could use this information. Thank y'all.